Dhanendra Kumar and I were in the first commission, and he was chairman of the Competition Commission of India, a man with tremendous patience who put up with all the arguments I made, and I learned a lot. Dhanendra Kumarji, do you really think privacy should come into the competition law? Or do you think it is an issue that comes up much later? The reason why I ask is my privacy is different from your privacy. So how does one get this into competition law and decide?
Thank you for your question, Geeta ji. I feel that privacy and competition law, several places, they impinge into each other. This matter also came up before the Competition Commission in the case of Facebook, when they also referred to their study report, competition study report, in the case of telecom sector. The data, volume of data, the big data, it is impacting the behavior of the firms in several ways. So some of the bigger firms who have control over big data, big volumes of data, mountains of data, and they are able to use that data for their advantage in various ways, and at times create barriers for the entry of new players by using or abusing or misusing that data in several ways. So what happens, coming to your question on privacy, that as an individual actor, I have my right for protection of data. And this was in the Indian competition context, as you would recall, this was upheld in the Puttaswamy case also, the Article 21 of the Indian Constitution. So privacy is the right of every citizen. And it has been so upheld in several ways. In the European context also, the GDPR, they celebrated Spanish law or Spanish judgment also. So when we have a right for protection of privacy, then there could also be a situation when the individuals, and this is a matter which is under consideration in the Indian data protection law, which is before the parliament. So they might take a view that the citizens would have a right to ask for deletion of their personal information or private data, in which case the volumes of data, the big data would also be impacted, and therefore the behavior of the firms also. So what I was meaning to say that at the end of the day, the privacy would also be in some manner intertwined with the competition law interplay. And to that extent, the right of the individual and the right of the firms for using it commercially, and at times the right of the society generally to know about the individual's data, they would all be impinging into each other, and the data protection law would have to come in a to balance the claims of each one on the use of that data. So I feel that privacy would have an interplay with the competition law, to answer your question briefly. Our competition commission, for that competition law, and for that matter, most other competition laws around the world, these laws were designed for the traditional markets, traditional economic markets. Now the shape and structure and the nuances, they have changed quite a lot in the digital economy, and as a result, the price factor has also undergone some change. It is not the question of monetary price alone which is relevant to the firms. It is also the value of the data which they reckon while evaluating the price or the value of the firm. For example, why should Facebook pay something like $19 billion for buying WhatsApp when its estimated value at that time, as people say, was about $1 billion at the most. So they probably assess the value keeping in mind the data which they would be able to have access, and then they would be able to use that data for a number of other applications. So the point I'm trying to make that the competition tools which had been drafted in our competition laws, in our case in 2002, in many other countries in various parts of time, they were probably not adequate to take care of this situation. The Competition Law Review Committee looked at this, and you referred to it. I was also a member. And also in the Competition Law Amendment Bill, which is pending before the Parliament, many of these issues have been discussed, and there have been matters relating to the deal size and so on, not only the value of the assets in monetary terms or turnover in terms of the enterprise, but also the deal size. So we are trying to take into account what would be the behavioral propensity of the firms in M&A or in dealing with the markets, and how can they distort the market by using that data. So altogether, the point I'm trying to make is that the entry of big data in the new digital economy is influencing the behavior, the propensity of the firms to intervene in the market, and in many ways distort the market at times. So the Competition Commission, or for that matter, the other jurisdictions also, they would have to evaluate whether the basic tenets remain the same, whether it is distorting the level playing field in the market, whether it is creating the entry barriers, or whether it is giving undue advantage, unfair advantage to certain firms and so on. So those are the kind of basic tenets which have to be seen at the touchstone of the new situation. So altogether, I feel that this is a situation where we have to evaluate the tools that exist with us and ensure that the principles of the competition law of creating the level playing field, equal opportunity, basically it means economic democracy, to give equal opportunity to all the players and protect the interest of consumers. Those things are taken care of by the existing tools or by modified tools which are under examination at the moment. I really wanted to add that when we talk of the competition and the benefits which would accrue to the economy as a result of the competition, it refers to both static and dynamic efficiencies and the benefits which would flow to the economy as a result of infusion of technology. So the job of the competition also is to encourage innovation, to encourage infusion of new technology and bring in new applications. And the firms also, they adapt the markets, they train the consumers, and they make them used to new applications, new appliances, new technologies, and that's how the economy progresses. There are new side applications also and stuff like this. So the job of the competition jurisdiction regulator is not only to promote competition in the market, but also to promote innovation and dynamic efficiencies. It's a continuous process. And to that extent, the use of data, when they accumulate data, big data and so on, and they use big data for bringing up new innovations and new applications, cannot be underestimated also. So it is not all that undesirable, it is not all that bad also. So the point I'm trying to make is we have to keep in mind the benefits of the new innovations and the application of data. When you mention about the privacy and the related issues, the confidentiality part also comes into, because at times it has been seen that the firms are very, very chary about and very protective about the confidentiality part for a number of reasons and legitimate reasons. They would not like their competitors and others to know about various parts. So to that extent, it becomes a competition issue also, more than the regulatory issue, because to the extent it impacts the defense of the party concerned, wherein you are examining the party about contraventions and so on, and if they what they said or their arguments and their position is also known to the competitors, it may put them at a disadvantage.